Mr Aurora.
My Lord, if I may pick up where we were about to leave off before the adjournment. My Lord, I've discussed this with my instructing solicitor who sits behind me, and we're both of the view that currently there is insufficient evidence to make a positive allegation of fraud against the solicitors in relation to this issue.
Yes.
But there are, my Lord, several points that I would like to, well, certainly one point, my Lord, it may develop into others, which I would like to take the court to in relation to that, because when I was, as your Lordship put it, sitting on the fence, I do maintain the submission that I made then, which is it's not necessary for us to maintain an allegation of fraud in order to show, to generate a successful wasted cost application.
And I'm not suggesting otherwise. I'm merely concerned to be clear upon the scope of the allegation that is said to give rise to the possibility of the wasted cost order. And
in particular, my Lord, could I take the court to a supplemental bundle 68 of 95, which is the second page of Mr Sarwar's witness statement. And it's paragraph 10 therein, because I do say that this effectively tees up a violent conflict of fact with what the claimant is saying in his letter, or former claimant is saying in his letter. What Mr Sarwar says at 10 is there is no evidence as to whether this firm did or did not take instructions from the claimant as to whether he held a directorship of the applicant company. And my Lord, I do say that flies very firmly in the face of Mr Hunt's allegation that he had discussed this all, I think, with a Mr Meacher was the name that we, if I recall correctly.
Yes.
So, my Lord, that being an example of a conflict of fact between these two parties, which I say has arisen as a result of Mr Sarwar putting in a witness statement.
Can we just break that down a moment? When Mr Sarwar makes his witness statement, Mr Hunt hasn't yet provided his letter. So when Mr Sarwar says there is no evidence, I dare say that was right, was it?
Bearing in mind, he's not saying from his own knowledge whether there was or there was not instructions, because he can't, because that's privileged.
Well, my Lord, I do take your Lordship's point that there is no evidence as to whether this firm did or did not. But they could have been silent as to that point. The witness statement could have been silent as to that fact, and he is there setting up a position where, once there is evidence, it is then appropriate to cross-examine on it, would be my submission.
Sorry, why?
Well, because he's made a positive contention.
No, it's a statement as to the absence of evidence. And you haven't shown us anything that predates this statement that does constitute such evidence.
Yes.
Therefore, nothing at the moment that you've shown us impeaches this statement.
The answer, my Lord, would be the fact that Mr Sarwar was given permission to respond to Mr Hunt's statement and chose not to. And therefore, I would say there is evidence that instruction was taken. Mr Hunt has set that point out. It is then appropriate for Mr Sarwar to be cross-examined on this issue.
Well, that somewhat depends on whether there's been a waiver of privilege, or whether, if there has not yet been a waiver of privilege, whether there's a future waiver.
Well, my Lord, that then does bring me back onto bring me back more into the thrust of my position. As a matter of fact, my Lord, Mr Hunt has subsequently waived privilege, but I accept that that's not a matter directly relevant to...
When you say as a matter of fact, I understand that you to mean that is your assertion.
Lord,
Can you point us to any document in which Mr Hunt says, I, Mr Hunt, waive privilege?
Not within the bundle, my Lord, because it's happened subsequently.
Right. So you're telling us that, unbeknownst to us, there is in fact an express waiver of privilege?
Lord, yes.
I didn't know that.
Okay.
But, my Lord, for the issue on the appeal, my Lord,
Sorry, just before you, I know you're getting diverted from where you wish to be, but so I understand, the express waiver arises how?
By way of an email to Mr Mitchell, I think to Mr Mitchell. My instructing solicitor in terms, well, in fact, Jonathan, can I have that phone back? Pardon me, my Lord, I have a note of what was said, but I'd rather read it verbatim. It's on DAC Beechcroft headed paper. I, Mr John Hunt of 11 Gloucester Road,
Hang on, sorry.
Nottinghamshire.
Headed paper.
S810PL confirmed that I have taken independent legal advice and agreed to waive legal professional privilege I have with Walker Preston solicitors, who were previously instructed to deal with a claim under the action number C36YP024 against Annolight Limited, Double T Glass Limited and Paragon Trade Frames Limited. Signed and dated 27th of August 2021.
7th of August.
27th of August.
27th of August 2021. Yeah.
But, my lord, I can, anticipating a point that may well be put against me to say, well, that wasn't a germane issue to the appeal because it wasn't yet raised. There I say one has to analyse what both Judge Godsmark QC and Mr Justice Saini are saying, because it is, I respectfully submit, a question of probabilities. I know I was being pressed on my what can justify my belief that Mr Hunt will attend, will participate. And my lord, I say, well, look at the facts, because Mr Hunt has provided a letter in a statement in which, to paraphrase Mr Justice, well, to quote Mr Justice Saini, he's thrown his former solicitors under the bus. He has now sent the waiver of privilege to those who instruct me. He did attend the last appeal hearing, albeit he hadn't got the memo that the matter had been shifted from an afternoon hearing to a morning hearing. So he is participating in the events. Now that's very different from a lot of claimants who are accused of fundamental dishonesty, who simply try to wash their hands of it and disappear. So that factual background, I say, is important. And those issues, I would say, certainly were before Mr Justice Saini when he exercised his discretion to the extent that he did. But I also say, my lord, that they were before Judge Godsmark QC.
All right, but can I ask you this question? You've made it clear that you are not alleging that there was any forgery by the solicitors of Mr Hunt's signature on the reply to the RFI. And that, of course, includes doing it without authority. So you're not making that allegation, but you seem to be making the submission that there is nevertheless a conflict between the evidence of Mr Hunt and the evidence of Mr Sarwar. Now, could you specify what conflict you say there is?
My lord, it chiefly concerns that the question about Ian Meacham of Walker Preston's drawing to his attention a signature on a document, and the question of whether he in fact was advised about.
So where's the conflict? Mr Sarwar may entirely accept what is said about Mr Meacham.
My lord, if he did.
Certainly you can't point to any statement of Mr Sarwar subsequent to Mr Hunt's letter taking issue with it, can you?
My lord, no, but I can't point to any statement from Mr Sarwar agreeing with any terms of Mr Hunt's letter. He's simply silent on
so
it.
silence equals conflict. Is that your submission?
Can I return, my lord, to the application statement by Mr Mitchell, if I may? Again, paragraph 8. It's the defendant's position the claimant solicitor failed to obtain proper instructions on the issue of him being a director. Mr Sarwar's statement is simply silent in relation to that.
Yes.
That, my lord, I would say is triable issue is probably the wrong word, but it is a conflict, yes. An allegation has been made.
Where is the conflict that you are relying upon between Mr Hunt's evidence in his letter and the evidence of Mr Sarwar in his witness statement?
Well, my lord, Mr Sarwar at paragraph 7 denies any negligent act or omission. Mr Hunt has described it as negligible. And the response from Mr Sarwar throughout is not to put forward any positive position on the grounds of privilege, and that's why I wanted to deal with privilege in terms of what was before Judge Godsmark QC and what was
privilege is waived 18 months later. How is Mr Sarwar supposed to anticipate that privilege is going to be waived 18 months later?
Well, my lord, the question though is bearing in mind it's an assessment of the discretion by Judge Godsmark QC and Mr Justice Saini, is what evidence was there before those two judges?
Right, so do you agree with Mr Marvin that the relevant discretion is that of Judge Godsmark?
Well, my lord, that was the way that I put it before Mr Justice Saini, yes, because I was saying that His Honour Judge Godsmark QC's discretion was correct.
It's common ground that we must view the matter then as it appeared before Judge Godsmark. So therefore we've got to put out of our minds the fact that recently privilege has been waived.
Well, your lordships would have to do that even if you're assessing the discretion of Mr Justice Saini.
Indeed so.
But what I would point to, though, is before Judge Godsmark, there did appear, and there was sufficient material before His Honour to come to a conclusion that it was likely privilege would be waived.
Is it, in your submission, a proper basis to order cross-examination upon an assessment of the probability of privilege being waived?
Well, my lord, at that point, having not yet seen the statement from Mr Hunt, that's all that it could be based on. And that's why I would say when it comes to Mr Justice Saini, the position is strengthened, because if your lordships are considering his lordship's discretion as well, then I say the position is strengthened, because by that point he's got the analysis that Mr Hunt is throwing his former solicitors under the bus.
So can you help us as to this? Given that you're not alleging forgery of the signature on the response to the RFI, what is the case that you intend to put to Mr Sarwar in cross-examination in support of your client's application?
Negligently pursuing the case of Mr Hunt.
And since when does that justify wasted costs?
Negligence. Pardon me, Lord? Oh.
So just bare negligence?
Lord, yes, to the extent, for example, that, thinking of the chronology now through my head, May 2019, this issue about directorship arises when the Part 18s are asked. I think there's then an adjourned trial and then a second trial that's aborted in December 2019. Effectively before starting, because of inadequate advice given to Mr Hunt about the prospects of his position.
Right, so you are trying to do this as a professional negligence claim without any protections. No pleadings, no disclosure, and Mr Sarwar is just going to be ambushed at trial with cross-examination on negligence without any proper particulars in advance. Is that really what you're suggesting?
Lord, it's not a prof neg claim in respect of, from Mr Hunt's perspective. It's negligent conduct of a claim by a solicitor on the opposing side, and improper, unreasonable, negligent act or omissions can form the basis of wasted costs. There will need to be causation established. I say that will be likely to be established by the evidence of Mr Hunt. In particular, his point about the the work being, quote, negligible. But further, my lord, we need to, respectfully I say we need to move back to a position because unlike those authorities cited by Maloney and Mr Marvin, the key difference here is the fact that Mr Hunt effectively has to blame his solicitors in order to escape the fundamental dishonesty finding. And that, I described it earlier to your lordships as an excluded middle. There is an excluded middle between Mr Hunt's defending himself of a fundamental dishonesty accusation and Walker Preston's justifying the way that they've handled the case.
Can I just try and break it down for a moment? Paragraph 8 of Mr Mitchell's statement, he says it is the defendant's position that the claimant solicitors failed to obtain proper instructions on the issue of the claimant previously being a director. Now, am I right in taking it that that is the allegation that is made against Walker Preston's?
Yes, it's followed by the paragraph beginning further. If the case had been properly conducted, the claimant solicitor would have advised the claimant of the
No,
same.
I follow that. That's causation.
Yes.
But the allegation, and the only allegation, is that Walker Preston's failed to obtain proper instructions on the issue of the claimant previously being a director.
From our perspective, my lord, yes.
Yeah. Now, can we just explore it a moment more? So you get to trial. Well, I say trial. You get to the hearing of the costs applications, and Mr Sarwar goes into the witness box, and you want to ask him about matters relevant to this allegation. Now, take, say, what Mr Hunt has said in his letter. So you inquire about what Walker Preston's looked into when they were framing the reply to the request for further information. And let's suppose that Mr Sarwar says, well, I didn't personally handle this, Mr Meechan handled this. And he further says, well, I imagine there was an attendance note. So what happens then?
Well, I think, my lord, the purpose of Judge Godsmark QC insisting that it was a partner with supervisory capacity is that somebody is in a position to answer the court or the courts or our questions in relation to the work. So,
and I see that, but it means he might not have personal knowledge. At any rate, somebody else might have been primarily dealing with it. So Mr Sarwar's in the witness box. You say to him, well, you didn't do the job properly when you were framing the answer to the request for further information. And he says, well, Mr Hunt himself says that Mr Meechan dealt with this. And there will be attendance notes. So do you then ask for disclosure of the attendance notes?
Well, I would have expected Mr Sarwar to have familiarised himself with attendance notes in advance of giving evidence about a case to which they relate.
Okay, so he says, well, I know there's an attendance note. Do you say, well, I'd like to see it, please?
I'd ask what it said. Yes, in circumstances where Mr Hunt has waived privilege, I'd be entitled to do so, I believe.
But here we are at the trial, as I'm going to call it, of the cost issues, without any order for disclosure beforehand, developing points that turn on the detail of the solicitor's file.
Well, my lord, yes, in circumstances where Mr Hunt, to quote his letter again, says, Walker Prestons have always been privy to all documents and information relating to my previous employments, and have never given me reason to believe there were any discrepancies within it.
So does that mean you need disclosure of all documents relating to those employments?
My lord, no, but Mr Hunt will no doubt be seeking those.
I don't suppose he will. He'll say it. He's not going to make an application for disclosure,
Well,
is he?
Mr Hunt, in order to defend himself against a claim, the allegation of fundamental dishonesty, will need to put the ball back into Walker Preston's court.
So he goes into the witness box, we'll say, and he says, I gave Walker Preston's everything. But there's been no prior order for disclosure. Nobody knows where they are in terms of the documentation. I have a concern that if we get this far, it'll all be a muddle, and an unfair muddle.
Well, my lord, it's not an unfair muddle in circumstances where Walker Preston have had the opportunity to put forward their case in advance. It's no good to say, well, we've put forward a very limited witness statement in the first instance, claiming privilege in respect of just about everything.
They didn't claim privilege. It was their client's privilege.
I mean, my lord.
They were obliged to protect it unless and until he protected it, and they would have been exposing themselves to serious consequences if they'd done anything else.
Apologies, my lord, misspoke. But in circumstances where Mr Sarwar's defence to the application is essentially to say privilege on behalf of the client, which I don't think is an unfair characterisation of his statement. Of having had Mr Hunt raise allegations against him, and then not taking the opportunity to respond with a statement in response, it's a little run for Mr Sarwar then to say, well, we're now at a hearing. I don't have all the information before me. I'm pleading ignorance, effectively. To switch his plea from privilege on behalf of his client to ignorance on behalf of himself.
But it's tricky because I can see an attraction in having the application against Mr Hunt heard with the applications against Walker Preston, so the judge can see the whole picture. But it also seems rather peculiar that you should found your case on evidence you hope to get from Mr Hunt in defending his fundamental dishonesty case.
Well, my lord, that's why our application is in two prongs, as it was described earlier by my lord friend Mr Marvin. It is in the alternative, and as I've said, there's an excluded middle between the two. It's either Mr Hunt is fundamentally dishonest, or I say Walker Prestons are guilty of negligent, improper, or unreasonable behaviour in relation to that. And it's the fact that there's the excluded middle which moves this case away from, for example, the hypothetical in Rydell and Horsfield, where so we cannot imagine a situation in which it would be appropriate to cross-examine. Well, but their lordships in 1994 were not ever having to deal with a situation where fundamental dishonesty was going to be alleged against a former claimant, and the only argument he'd be able to make in response would be to say, well, I blame my solicitors.
Can you remind me, what's the basis of your allegation of fundamental dishonesty? In what respect do you allege that Mr Hunt was fundamentally dishonest?
In signing a Part 18 request, which states categorically I was never a director, in circumstances where that was going to have a significant bearing on the question of liability, and so then therefore went to the heart or the root of the claim. No.
I mean, of itself, cross-examining, suppose Mr Hunt directs his evidence at that allegation and says the sort of thing he says in his letter. It's hard to see how cross-examination on that particular matter is going to help you in your claim against Walker Preston. You want him to say lots of other things.
It's not a question of wanting him to, my lord. He may, of course. That is a possibility. But I'm sorry, I'm not following your lordship saying.
Well, if you say to Mr Hunt, the basis of alleging fundamental dishonesty against you is your signature of the Part 18 answer.
Yes.
He says, look, I discussed this with Mr Meechan. Mr Meechan queried my signature, and when I thought about it, I thought, well, I don't remember signing any such document, and I never thought I was a director. Therefore, it was perfectly honest of me to sign the response as I did.
My lord, per Ivy and Genting, it would have to be an objective test at the start in terms of his knowledge. And
No, I don't think that's right. You apply an objective test once you've established the subjective state of mind.
my lord, yes. But his subjective state of mind in relation to Part 18 was, I that is my name, that is my birthday, but it's not me.
Well, he says,
But because he can't remember.
yeah.
And his solicitor has suggested to him that the signature on the document is forged.
But his Part 18 response doesn't say, I don't remember.
No, but that's the
Me.
state of mind. That's the hypothetical state of mind on what he says in his letter.
But it would be dishonest to assert a positive when actually the true answer is I don't remember. The positive that he's asserted is it's not me. It's not I don't remember if it was me or not.
I was suffering extreme stress and cannot recall signing any such document.
Well, yes, but isn't that brings us back to the point of the ambiguity about what document he's referring to here? Because is he referring to a document such as my lord indicated, one on Company's House, or is he referring here to the Part 18 response?
Well, it can't be the Part 18 response because he says in terms the document was one I had allegedly signed which made me a director of the firm.
Yes, and my lord made that point earlier. But if that's the case, then that's the question about extreme stress doesn't go to the question of the honesty of the Part 18 response. If it's not concerning the Part 18 response.
Well, he says, I agree there are variations on this. I mean, maybe when you cross-examine Mr Hunt on this thesis, you establish that he really didn't believe that he wasn't a director, and therefore he was fundamentally dishonest. I'm not sure. I think were you suggesting earlier, well, either you win against Mr Hunt or you win against Walker Preston's. I mean, on that basis, you'd win against Mr Hunt. But suppose instead you don't win against Mr Hunt because you don't persuade the judge that Mr Hunt didn't believe what he said when he signed the Part 18 request. How are Mr Hunt's answers going to help you against Walker Preston's?
Well, my lord, that is one possibility in terms of how the evidence might play out, in which well, my lord, no, because it's still their obligation to advise him of any discrepancies within the documentation that he's got. So,
They seem to have done that.
well, not
to
according to
him.
Mr Hunt.
Well, he says, yeah, Meechin told me about this problem.
Well, it's the line above that I was referring to, my lord.
All right, but can we come back to your application? Because as I understand it, your position in this court is that notwithstanding the fact you told Judge Godsmark you didn't want to cross-examine Mr Sarwar, by the time it came before Mr Justice Saini, you reversed your position and were supporting an order for cross-examination of Mr Sarwar, and that is still your position in this court. So therefore, our starting point is the jurisdictional basis you're revoking is 32.7. You say you're entitled to cross-examine Mr Sarwar on his witness statement. But I'm still at a loss as to what statement in that witness statement you are seeking to challenge, because the purpose of the statement is primarily to deny the allegation of forgery, which you are not any longer pursuing. So which part of the witness statement of Mr Sarwar are you going to be challenging in cross-examination, as opposed to questioning him about a whole row of things about which he has so far been utterly silent?
Well, my lord, paragraph 9, above the one that I took the court to a moment ago, the discussion about the reasons for doing so are protected by privilege. In light of what Mr Hunt has said, my lord, that does need to be explored, because Mr Hunt's position appears to be that they simply didn't advise him properly in relation to his prospects.
Is that part of your allegation? You say that they failed to obtain proper instructions on the issue of his previously being a director.
So I'm a bit baffled by this. Which sentence in paragraph 9 are you saying is untrue? Surely it's correct it was for the claimant to decide whether or not to discontinue his claim.
My Lord,
Surely it's correct that he did discontinue the claim on the day of the trial, and as at that point in time it was correct to say that his reasons were protected by privilege.
my Lord, I don't have to say something is untrue in order to challenge the cross-examination. The point is being put by Mr Hunt that he was poorly advised throughout the course of his claim. That prima facie would be an arguable case for wasted costs, to the extent that costs have been caused to be incurred as a result. And
so, to be clear, your proposition is that you are entitled to cross-examine Mr Sarwar on his entire conduct of Mr Hunt's claim to establish professional negligence.
particularly, my Lord, when Mr Hunt is making allegations against him, yes. Well, to the extent that Mr Hunt makes allegations against him, rather than, pardon me, again misspoke, but to the extent that Mr Hunt makes allegations against the way that Walker Prestons have handled his claim,
And why is that not going well beyond paragraph 8 of Mr Mitchell's statement? Bear in mind that the practice direction requires you to set out what it is alleged that the solicitors have done wrong. Mr Mitchell complies with that obligation in paragraph 8, which is purely about instructions redirectorship. Whereas now you seem to be envisaging a wide-ranging cross-examination of the entire conduct of the claim. Without even the benefit of disclosure.
well, my Lord, if I could narrow it to some degree, paragraph 16 of, which is page 7 of 95 in the supplemental. Which makes allegations concerning a failure to respond to correspondence dealing with that issue of the Part 18s. Again, if Mr Hunt's position is that he didn't what he said. Never was this document or my signature on it an issue to Walker Prestons with regards to how successful they thought my claim would be. There is still a failure to act with the requisite propriety, reasonableness or lack of negligence in relation to those issues. And given that Mr Mitchell points out that that leads to a very late notice of discontinuance being served, then I would still say that wasted costs can flow from that. So when your Lordship characterises it as a wholesale conduct of the claim by Walker Prestons, it is narrower than that. And that does bring us out with the way that the Court of Appeal in particular enjoin parties not to behave in Rydelt and
yeah, but what it comes down to, and I think you're accepting this, but if you don't accept it, please enlighten me. You are wishing to put to Mr Sarwar, in cross-examination, matters which he has not covered in his witness statement.
My Lord, yes, I do think that. I think that's fair, yes.
Yeah.
Can I just ask this? I mean, it's very difficult to really put out of one's mind all that we now know has happened in the intervening 17 or so months since the April 2020 order, but trying to rewind, the position as it stood before the judge was that Mr Hunter said through counsel that he didn't sign the Part 18 response, and Mr Sarwar had said that he did. So there was an issue. and there was going to be a sequence of exchanges of evidence, or at least opportunities to provide further evidence. Was the judge working on the footing that there was one issue, and there might well be others, in relation to which Mr Sarwar should be available for cross-examination? Or was he working on the footing that there were identifiable issues between the parties already, and that was what should be the subject of cross-examination, or something else? It strikes me that what he was endeavouring to do, possibly an unachievable aim, was to gather together everything for a single hearing at which everything could be thrashed out.
Yes.
On these two separate issues of whether there should be a Quox disapplication and all. And they're not necessarily, I suppose, mutually exclusive, but anyway, or a wasted cost application. That's, seems to me, part of the problem here. He's trying to forecast what's going to go on over a period of months. And make appropriate procedural orders without any sort of intervening case management.
I think your lordship may well be correct, and if we turn back to try to find the original order from Judge Godsmark following the trial, the aborted trial in December, it does appear as if His Honour wanted to lump everything together. Yes.
Yeah, and it couldn't happen because the solicitors hadn't come off the record, and then there was an attempt to get things back on track, but with only one further hearing envisaged.
Well, His Honour was trying to adopt a summary and...
I'm not being critical of anyone in relation to this, I'm just trying to set the scene for what was going on, and what he was trying to achieve with his order that's under challenge.
Well, my lord, I think I agree. I agree in that is what Judge Godsmark was attempting to do in that one hearing. Had Walker Preston's come off the record in good time, and Mr Hunt been present at the telephone hearing, it might well have been that the issues would have been resolved without cross-examination at that point. Given that we found ourselves in a procedural mess at that point, it was an opportunity, and I say in line with judicial discretion, an appropriate one, to then set directions to try to iron things out more correctly, I suppose.
And on that footing, the provision for cross-examination was either no more than he should be there in case, or it was entirely speculative, or predominantly speculative.
Well, I think, my lord, that is probably something of the difference, and I'm trying to clarify exactly how to put this, because the assumption on a lot of cases would be that it would be speculative. Yes, in a typical case devoid of these facts, it might well be thought that suggesting that a former client would waive privilege would be speculative. Yes, but that's why I say this case is different, and that's because of the issue about fundamental dishonesty. And I think Judge Godsmark does refer to a question where he says it's likely to have questions of waiver of privilege.
Yeah. Well, because he'd already said, whether this was a misunderstanding or not, he said through counsel he didn't sign a document which had his signature on it.
Yes, which takes, but that, again, that does take this case somewhat out of the norm, in which you wouldn't normally expect. And I know Lord criticised the way I characterise this as being a likelihood of privilege being waived. But for a case managing judge, that's not an unreasonable way to look at this, is my position. In light of the facts that were there, in light of the way the trial had fallen apart at 11:59 before 12 o'clock start or something.
Sorry, do finish.
No, my lord.
So you talk about normal way things are done. Let me just run past you how one might suggest things would normally be done, which is solicitor puts in a witness statement. The party seeking costs then issues an application notice saying, please can I have an order that the solicitor be cross-examined upon his witness statement. Everybody comes to the hearing knowing that that's the application that's going to be made. And then one of the things that the judge can ask himself in deciding whether or not to make that order is, well, what issues is it that is proposed to cross-examine the solicitor upon? And when the answer comes back from the applicant, I don't want to challenge any statement he's made in his witness statement, but I want to cross-examine him about other things that he's been silent on. One might think that that would lead to a natural conclusion.
But in that normal course of affairs, my lord, we're not dealing with parties who have attended, anticipating a resolution to the issue, and then being in a situation of having, well, we now need to set case management directions. So yes, that would be a normal course of events. It wasn't this course of events. But that's not a reason for criticising the way that it was approached by Judge Godsmark. It was still amply within his discretion to deal with it that way.
Another way it could have been dealt with, I suppose, is that when you're setting the timetable for evidence, you include a step at which any party requiring an opponent's witness to attend for cross-examination should give notice of that. And then the question of whether there should be any cross-examination and its extent would be decided at the hearing.
My lord, yes, and that would be a better way of dealing with it. But the question isn't whether this was a perfect case management approach by Judge Godsmark. The question is whether it was within the realm of reasonable judicial discretion.
Well, if it comes to the same thing, then it's quite an important consideration. If in effect that's what he was doing, just in a different way, making sure the solicitor was there in case someone wanted to cross-examine him.
Yes. My lord, if I could take us back to the authorities. I appreciate I started by suggesting I was going to go through the authorities. It seemed to have been somewhat sidetracked.
Yeah, quite.
Apologies for that. I do commend the reasoning of Mr Justice Underhill in the Godfrey Morgan solicitor's case, as I did to Mr Justice Saini. I say it's most in accordance with the facts, and critically, the fact that there is a real issue about privilege. We now know that it's been waived, but even before Mr Justice Saini, using the phrase "throw them under the bus," it's fairly clear, in my respectful submission, that that was the grounds, the reasoning, the logic to follow, as did the High Court judge. It's also, my lord, noteworthy, I say, that so far as I can tell, the only one of the four authorities in our authorities bundle where cross-examination was actually ordered and then challenged by way of appeal is this one. Because I don't think it was done in any of the joint cases in Rydal and Horsfield. It certainly didn't form part of the ratio of any of the individual cases that I could see. And as I think was discussed between your lordships and my friend Mr Marvin, the other Employment Appeal Tribunal case, that of Mr Justice Elias, the issue there concerned written comments on submissions that had been made. Of course, I would respectfully agree with the position taken that it would be a bizarre turn of affairs if parties could not place comment on any written submissions put in by another party, no matter, for example, just how fanciful they were. So it doesn't appear to have been the decision and certainly not the ratio of the decision before Mr Justice Elias. And in that case, it's quite clear privilege wasn't waived because paragraph 22 refers to the privilege issue head on. That's page 8 of the judgment, paragraph 22. Furthermore, a particular problem arises in circumstances where the privilege of the client is not waived. In those circumstances, it will be a very exceptional case indeed where a court will be entitled to infer a party is abusing the process of the court by pursuing a hopeless case. Well, my lord, even before His Honour Judge Godsmark, the signs were clear that that was not this position. And certainly by the time it came to Mr Justice Saini, it was obvious it was not that position because, as I say, the thrown under the bus comment. So as Mr Justice Underhill pointed out, I think, the comments of Mr Justice Elias in this in the Radcliffe, Deuce and Gamma case are strictly obital on that basis. And finally, my lord, in relation to Rydal and Horsfield, I know your lordships have been through this in some detail with my learned friend Mr Marvin, but there was one point raised about this, the interpretation placed on it by Mr Justice Underhill of interrogatories being, interrogate meaning interrogatories. My lord raised the point about the preceding sentence refers to discovery, My lord, the only point I would add to that, to compound it, is to say the sentence preceding that refers, I think, to complex pleadings. And that, in circumstances where the following sentences are discover and interrogate, I say provides very clear context.
And the sentence afterwards is hearing.
Pardon me, my
The
lord?
sentence afterwards is about the hearing. So it goes pleadings, discovery, interrogatories, hearing.
Hearing, my lord, yes. Yes. So I say that's a logical, it's a logical interpretation placed upon it by Mr. Justice Underhill. But critically, I appreciate and I don't seek to disagree with my learned friend in the sense that Right Honourable Horsfield is, the Master of the Rolls was attempting to set down general guidance, but it doesn't appear that focused argument was taken on this point about the procedure. Because, of course, from the head note, we do have a detailed note of the arguments being put forward by counsel. It doesn't appear that was the essence of it. It is that one comment in one paragraph, and it doesn't have the analysis that's placed upon it by Mr. Justice Underhill. So, to the extent that my learned friend's position is that there is a blanket prohibition on solicitors, and that he relies on Right Honourable Horsfield to pursue that, I say respectfully he's wrong. To the extent that it is maintained that there is a blanket prohibition, I say it has to be read through the lens of the way that it was approached by Mr. Justice Underhill, which is on certain facts and in certain circumstances. And this case certainly would be one of them, in light of the issues raised between the claimant and his former solicitors, and also, my lord, in relation to fundamental dishonesty, which simply would not have been imaginable to the Court of Appeal at the time of Rydell and Horsfield, because by the time the claim was finished in those cases, in any of those claims, there was then no need for a further hearing to determine the claimant's liability for costs. That is a uniquely new feature, because it concerns only the question of fundamental dishonesty, and it requires an oral hearing, as Judge Godsmark clearly anticipated. It requires oral evidence from Mr. Hunt. And in those circumstances, it's the proper case management order to make, to say, well, there should be oral evidence on both sides. And that's the position in which Judge Godsmark found himself, and that's the position which Mr. Justice Saini adopted and agreed with, and that's the position I commend to your lordships today.
Sorry, can I just tease out something that you just said and see if I've understood it correctly? You referred to it requiring evidence from Mr. Hunt. Now, the position before Judge Godsmark was that Mr. Hunt wasn't present on the telephone call, and it appeared that he didn't even know that the hearing was taking place because Walker Prestons were still on the record, and Mr. Trevelyan was candid that they hadn't notified their former client of the hearing. So, in those circumstances, are you saying that Judge Godsmark was A, acting with jurisdiction, and B, properly exercising his discretion to make an order for Mr. Hunt to give oral evidence, given that Mr. Hunt wasn't represented, wasn't present, didn't know anything about it, and hadn't put in any evidence yet?
If I remember correctly, my lord, it was Judge Godsmark QC was essentially looking to give Mr. Hunt the opportunity to put his side. That certainly was how it
to be
played
sure,
out
but you would
in
refer
December.
to a requirement that he give oral evidence.
Well, in order to absolve himself of fundamental dishonesty, he would have to give oral evidence, my lord.
Really?
Lord, yes, in these circumstances, where there's a Part 18 request that is clearly incorrect, that...
Well, that's your case that is clearly incorrect. But what if Mr. Hunt decided that he wasn't going to give any evidence and make a submission of no case to answer? Are you still saying he could be cross-examined?
If he hadn't put in a statement, my lord, then no, because there wouldn't be anything on which to cross-examine him.
Right.
But once he's done that, then...
Suppose he now says he's not going to rely on that letter.
Well, my lord, all I can say is that he hasn't said that as yet, and the trajectory of the way that he has behaved appears to be going in the opposite direction.
To be sure.
We'd be crossing a very different bridge, I think, if we, for example, my lord, we'd be crossing a very different bridge if neither Mr Hunt nor Mr Sarwar had put in witness statements, as I think was acknowledged before Mr Justice Saini when discussion of Rule 32.7 arose. But this is an appeal, my lord, about, in circumstances where statements have been put in, whether there is a
Mr. Hunt's
blanket
statement
prohibition.
hadn't been put in at the date the order was made. This is part of the point of asking the question. It goes to my Lord Justice Warby's point that this order was grossly premature. Because the correct sequence of events was to see, first of all, what evidence was submitted by way of written witness statement, then for parties to make any applications they were advised to make with regard to cross-examination, and then for a decision as to what cross-examination would be permitted. Whereas this order took it all back to front, didn't it?
Well, my lord, the exigencies of the situation.
What exigencies?
Well,
because the hearing couldn't be effective, as the judge quickly recognised. So what exigencies were there?
Of trying to adopt a summary, fair procedure rather than allowing it, as the Court of Appeal in Rydell and Horsfield suggested not to, of letting it run into a multi-day mini-trial, effectively, of trying to get to the bottom of the issues. And it hadn't been helped, my lord, by the way that Walker Preston's had acted in keeping themselves on record for Mr Hunt. And it would be quite something, I respectfully say, for Walker Preston's having acted in that way to keep themselves on record for Mr Hunt, to then say, well, because we're still on record for Mr Hunt and cause this hearing to be aborted, we now say that no further direction should be set. It would make a nonsense of the position.
Now, I know you've been taken in this direction and every other direction by the court. You've covered a lot of ground. What ground do you need to cover yet?
Lord, given the narrow nature of the grounds of appeal, such that there is a blanket prohibition on solicitors giving live evidence, being cross-examined, I say nothing further, not least because the argument from authority, as my learned friend Mr Marvin has put out, I submit, has been shown to be incorrect. And to an extent, my lord, I've attempted to assist the court as best I can, but the focus should be on those narrow issues in the appeal, as they were before Mr Justice Saini. And that, I submit, leads to a situation that the appeal should be dismissed. Can I assist the court with anything further?
Thank you very much, Mr Aurora. Mr Benton.
May it please your lordships. Your lordships, I've heard a great deal of oral submissions, so I'll endeavour to keep my submissions relatively brief, given that a number of issues have overlap. My lordships, as the court will be aware, the underlying claim was a noise-induced hearing loss, in which the appellant represented Mr Hunt. And clearly, in the context of a noise-induced hearing loss, the provision of hearing protection is of crucial importance, both on a number of issues. I think it touches on both causation and liability. And I think the starting point, your lordships, is the order of Judge Godsmark, which appears, forgive me, my learned friend, Mr Marvin, Queen's Counsel, referred to a tabulated bundle. I don't have tabs, regrettably.
There you're in the same position as me, Mr Denton. So I've got page numbers. There seem to be two page numbering systems, but actually I don't think they've caused a real problem. So are you in the core bundle or the supplemental bundle?
My apologies, my lord. It's the updated supplemental bundle
Yep.
I'm referring to, page 12. No doubt the court would have flagged that up
Yes.
in any event. This is the order to which both my learned friends have referred. And this is the order made by Judge Godsmark in December 2019, which contains a number of recitals. The one of which indicating that the court was informed by Claimant's counsel that the claimant did not sign the Part 18 response, and the court similarly makes the recital, the defendant's making an application to disapply qualified one-way cost shifting and or wasted costs. In that regard, the court thereafter, your lordships will note, that a cost order was made in favour of the defendants, but that determination was to be held over to be heard by Judge Godsmark following compliance with the subsequent orders one can see, and that those orders refer to any applications dealing with both the disapplication of qualified one-way cost shifting and or wasted costs to be made by the defendants to respondents today with an application in response. Now, your lordships will note that the defendants made applications in similar terms, and that is by reference to the Part 18 response. In respect of the third respondent, my lords, the application appears at page 52 in the supplemental bundle. It's an application pursuant to Part 44.16, that is the disapplication of qualified one-way cost shifting, and Part 46.8, that is the wasted cost jurisdiction. And in response to my Lord Justice Newey's earlier question concerning the adoption of the first respondent's approach, one can see on page 56, my Lord, that those instructed me adopt the witness statement and the allegations contained therein of Mr Mitchell because they naturally fall within the purview of his knowledge, because they deal with issues that were raised on the day and were raised by the first respondent, third defendant.
But can you help us as to this? Why was the question of whether Mr Hunt was or was not a director of Annolight of any relevance so far as your client's application for costs was concerned?
It was relevant, my Lord, because if one looks at the fifth defendant's application, the second respondent who played no part in this appeal, on page 63 of the bundle, this is the witness statement of Mr Bloomberg, in particular paragraph 10. And we say it's relevant because the claimant had advised in his witness statement that the duties whilst employed by the third, fifth and sixth defendant were basically the same. And so if it transpires that he was in fact a director of the defending company, that is something that we would pray in aid.
Sorry, I'm a bit puzzled by that. First of all, this witness statement came in 2 days after your instructing solicitor's witness statement. So how does that assist us in interpreting what he meant by his statement?
My Lord, forgive me. The reference in Mr Bloomberg's statement is reference to the claimant's witness statement that was before the court for the hearing before Judge Godsmark, the aborted trial.
Yes, but we're trying to understand what Mr West meant in his statement of the 8th of January, and you refer us to a witness statement of Mr Bloomberg dated the 10th of January, which obviously Mr West couldn't have seen and wasn't referring to.
Indeed.
Right. So we can't construe Mr West's witness statement by reference to a subsequent witness statement by another witness. Now, then the next question is this. Correct me if I've misunderstood, but I've never understood there to have been any issue in the underlying proceedings as to whether Mr Hunt was a director of your client company.
My Lord, no.
Right. So I'm still, and therefore it follows it was never part of your client's substantive defence to the claim that Mr Hunt was a director of your client company, and therefore there could be no claim.
My Lord, no. But of course, if the court were to find that the claimant was fundamentally dishonest in any material respect, and certainly in respect of his employment and the facts associated with his employment with the third defendant, that may well have an impact as regards the sixth defendant's allegation of fundamental dishonesty as against the claimant.
Just explain that to me, because I'm struggling to understand that. So let it be assumed that Mr Hunt says in the underlying proceedings, I'm not a director of Annolight, and let it be also assumed that was false to his knowledge. One can understand that in those circumstances, Annolight have reason for grievance because a claim has been brought against them on a false basis. But why does that mean that the claim brought against your client, when it's common ground that Mr. Hunt was not a director of your client, is also brought on a false basis?
Indeed. My Lord, the submission I would make is if the court were to find the risk of repetition that the claimant has been fundamentally dishonest in any material respect, then that will impact on his claim in toto as against all three defendants.
So the submission is that dishonesty as against one defendant because of a false allegation that's relevant to the claim against that defendant knocks out all other claims against all other defendants, even though the dishonesty is not relevant to the claims against those other defendants.
My Lord, that would be my submission, but by reference to Mr. Bloomberg's evidence, and I appreciate that the application of the witness statement it was not drafted in the most felicitous of manner.
Can I try to pin you down on what it does deal with, especially in the light of where we are now? Now, Mr. Mitchell, in his witness statement, talks about questions being raised in relation to the signature on the response to the request for further information. Mr. Aurora has fairly, and I'm sure correctly, accepted that that's not an allegation. He can't sustain an allegation of Walker Preston's signing the answer without authority on the evidence that's available. So let me pause there. Are you alleging that Walker Preston's signed the response without authority?
My Lord, no. In the light of paragraph 11 of Mr. West's statement, that is the case. We would adopt the position as Mr. Aurora and Malone Friend has indicated to the court.
Yeah. So can I just pause there one moment? Now, what we then have is Mr. Mitchell explaining in paragraph 8 of his witness statement that his client's position is that Walker Preston's failed to obtain proper instructions on the issue of Mr. Hunt being a director. Is that an allegation you're relying on?
My Lord, yes.
So let me just circle around that for a moment. To make out a wasted costs claim, you need to show impropriety, negligence, whatever, and that it caused you loss. So your case is that failing to take proper instructions on whether or not Mr. Hunt was the director of Annolight caused your client loss.
My Lord, no. But the question of, or the points raised in the witness statement and the application on behalf of the third defendant is inextricably linked and has had an impact on the sixth defendant's conduct and caused the defendant to incur greater costs. The claimant having discontinued on the first day of trial.
I'm sorry, I don't think I have got myself clear. So what Mr. Mitchell is saying is Walker Preston's failed to take proper instructions on whether or not Mr. Hunt was a director. So how did that cause you loss?
My Lord, the point we would make is if the court were to make a finding of fundamental dishonesty in respect of that aspect, then we would have invited the court to make a finding in respect of the entire action.
And you were saying that a moment ago, but why does that help you against Walker Preston's? With Walker Preston's, you need to show that they did something wrong in the course of the proceedings, not later, which caused you loss. And the something wrong you're talking about is Walker Preston failing to take proper instructions on whether or not Mr. Hunt was the director of Annolight. So why did that cause you loss? How can it be said to have caused you loss?
My Lord, that in and of itself didn't cause the sixth defendant loss. but it is to a certain extent inextricably linked to the conduct points, which one can see in paragraph 12 of Mr West's statement.
Okay, so I'm not sure about the inextricably linked bit, but so then we come on, as you say, to your other grounds, and you point out that different things have been said at different times in relation to the provision of hearing protection. Now, we know from Ridehalgh and Horsefield, and anyway, it makes obvious sense, that a solicitor has to be clearly told what it is that he's alleged to have done wrong. So far as you're concerned, what is it that Walker Preston's are said to have done wrong?
My Lord, can I briefly break it down before getting to that point? The question of conduct is raised, and as I've indicated to your Lordships at the outset, in the context of a noise-induced hearing loss case, hearing protection is a material issue. On the 3rd of December 2014, the claimant solicitors had confirmed that hearing protection was provided for the claimant's use during his employment with the defendant. The particulars of claim similarly indicate that no hearing protection was provided for the claimant's use. The first medical report, the claimant sought reliance upon a medical report of Mr Zaitoon, who is a consultant otolaryngologist. In his first report on the 1st of August 2015, he confirmed that hearing protection was provided for the claimant's use. But in a report just over a month later, 4th of September 2015, he confirms that no hearing protection was provided. Now, understandably, Part 35 questions were raised of Mr Zaitoon, and in those responses sometime later, he confirmed that he was advised by the claimant's solicitors that his understanding of the claimant having been offered hearing protection was inaccurate. But then there's a yet further discrepancy, because in a Part 18 response signed by the claimant on December 2017, he indicates the foam earplugs had been introduced by the sixth defendant, but the use was not enforced. So we have an issue, my lord, that we have a material change in the nature of the expert evidence. The other issue, my lord, is raised at paragraphs 18, 19 to 20, and that was in the first, there was an adjourned trial before Judge Godsmark in Derby before Her Honour Judge Coe. In that trial bundle, the first report of Mr Zaitoon appeared, but in the subsequent trial before Judge Godsmark, the first report of Mr Zaitoon was absent.
And do you say that caused you loss?
My lord, yes, because the question of hearing protection and whether or not, well, there are competing and differing versions of events.
Can we just break it down? You've explained the different things that have been said through the pleadings and the expert evidence, but then you've drawn attention separately to the problem with the trial bundles. Do you say that the problem with the trial bundles caused you loss?
Well, that in and of itself, but it remained, well, Judge Godsmark envisaged the parties making an application. We made an application, and the witness statement from Mr Sarwar doesn't deal with any of the points contained within it.
Sorry, just so I understand the framework before we get to Mr Sarwar. Did the problem with the trial bundle cause you loss?
In and of itself, my lord, no.
Yep. So then we're left with the contrasting, inconsistent accounts of whether or not hearing protection had been provided. So that's the basis, I infer, of the complaint against Walker Preston's. So what in a sentence is the overall overarching complaint against them?
Well, there's clearly an unexplained, well, there is an explained change of position in the medical evidence. Mr Zaitoon has indicated that it was the claimant's solicitors who informed him he was in fact incorrect when saying that the claimant was provided with hearing protection during his employment with the sixth defendant. That was thereafter changed, but then the claimant himself confirmed thereafter in Part 18 responses that hearing protection was provided for his use.
So, give me the punchline. What is the allegation against Walker Preston?
That there was improper or unreasonable or negligent instruction to Mr Zaitoon to change contents of the report.
So it's all about the change between the first report and the second report.
Indeed, my lord.
So how did that cause you loss?
Well, one will note, my lords, the date at which the reports were provided. Clearly that the case proceeded on the basis for some time that there were discrepancies contained within the evidence, culminating in trial and culminating in a discontinuance of trial. The engineering evidence in a noise-induced hearing loss.
I'm sorry, you seem to be going off onto a different topic. Let me rephrase the question. Suppose Mr Zaitoon's first report had stood and there'd never been a second report. How would your client's costs have been any different?
In those circumstances, my lord, there would be no material change. But in terms where he's changed his evidence...
so what's the loss you're claiming?
Well, it's the loss of the costs of the action, the wasted costs in the pursuit by the...
How can the costs of the action be wasted as a result solely of the change of Mr Zaitoon between his two reports with regard to whether hearing protection was provided to the claimant or not?
My lord, because this issue impacts on both the question of liability, limitation and indeed causation. It's highly material to a number of issues.
But you would have had no claim on this basis if the first report had stood.
Well, there's the issue of, clearly the issue of limitation and or engineering evidence. But we say it is a material change in his position. And it's unexplained.
Just to be clear, you were explaining that the allegation against Walker Preston is that there was improper or negligent or whatever instruction to the expert to change the medical report. So you say either that Walker Preston knew that it was untrue, what they were asking him to say, or that they ought to have known it was untrue?
I would submit, my lord, that is both of those points are the case only because it is from Mr Zaitoon and his Part 35 response. I have, my lords, noted down the exact response from Mr Zaitoon, if I can indicate to the court. He has indicated, after preparing my report, I allowed a period of 45 days or so for the claimant or his representatives to address issues of fact. I was advised by the claimant's solicitor that I was inaccurate in my understanding of Mr Hunt being offered hearing protection at Paragon Frames Limited. I corrected my report. But then thereafter, the claimant confirmed in a Part 18 response that he was provided with hearing protection.
So you're adopting the proposition that hearing protection was provided, that the solicitors knew that, or should have known it, and despite that gave an instruction to the expert to change his report to say the contrary.
That appears from the...
So that's improper conduct?
Indeed.
Or at least negligent conduct?
Indeed.
And as I understand, I think I've understood that you're saying that this aspect of things can't or shouldn't be seen in isolation from the matters that are being raised by Annolight, even though they are separate.
Indeed.
Not that one causes the other, but that they are twin aspects of the overall conduct of the action.
My lord, yes.
Were you saying earlier that if there hadn't been the problems with the case about being a director of Annolight, that case wouldn't have been continued, that claim would have been dropped earlier, and that would have had an impact on the costs of your client? Or did I misunderstand that?
That may well have had an impact on the cost of the client once that clear discrepancy was highlighted to the claimant. But in terms of response, my lord, Mr Sarwar, in his statement, forgive me, I think it's in the supplemental bundle, paragraph, page 67 in the supplemental bundle.
Yeah.
He appears to preface the contents of the statement, paragraph 3 of the statement, on the basis that the statement was limited to dealing with the third defendant's application for wasted costs against the firm. And of course, there was an application made by the fifth defendant and indeed the sixth defendant.
Yes. Are you saying he was compelled to provide evidence in response to those applications as well?
Save for, my lord, there is a clear order made by Judge Godsmark for a response to the applications made by the defendants in respect of the disapplication of qualified one-way cost shifting and or wasted costs.
Are you saying that the judge had power to order a witness to give evidence? And if so, where do you find that jurisdiction?
My lord, no. And clearly they've complied with Judge Godsmark's order by providing the witness statement. There is a clear order there indicating to the court.
But you seem to be submitting that there was something wrong in Mr Sarwar limiting his statement to the third defendant's application. Could you articulate for me what you say was wrong?
Well, my lord, I say the order of Judge Godsmark was quite clear in terms of what was required from the parties. The defendants...
So your submission is that Mr Sarwar was in breach of the first order?
My lord, forgive me 1 second. My lord, on my reading on page 13 of the bundle, the supplemental bundle, the order of Judge Godsmark, it is clear in terms. Any application to be made by the 10th of January, subject to paragraph 5, any responses to the application notice to be made by way of a witness statement with the statement of truth, to be filed by 24th of January. And there is the qualification that the witness statement ought to be by...
So your submission is that when the order says any response, we are to interpret that as meaning the respondent to the application must respond and must do so by witness statement.
My lord, no, it's not mandatory in its import.
But you were submitting that Mr Sarwar was in breach of the order.
Well, the observation I made, my lord, is that Mr Sarwar doesn't deal with any of the points raised in the sixth defendant's application.
Can I just break it down a moment? Is it your submission that if Walker Prestons wanted to defend, they had to set out their reasons in the witness statement from Mr Sarwar?
My lord, yes.
Is that consistent with CPR 46.82?
Forgive me, my lord.
Because 46.82 says that the court will give the legal representative a reasonable opportunity to make written submissions. Now, submissions don't have to be evidence.
Indeed. It then goes on, or if the legal representative prefers to attend the hearing before it makes such an order.
Yeah. So,
But I'm a bit baffled by this because I quite take the point, as you made clear to your application in the course of your submissions to Judge Godsmark, the reason why you were applying for an order for cross-examination at that stage was precisely because Mr Sarwar was silent as regards the points made in your client's application. You said that in terms. You were perfectly clear about that. But what you didn't say was that they were therefore in breach of his previous order. And I've not detected that point having been made in your skeleton argument on the appeal, nor is there any respondent's notice.
My lord, no. My lord, in terms of the transcript before Judge Godsmark, which appears in core bundle 243, the learned judge on page 247, it inquires as to whether any evidence is to be required by means of cross-examination, and inquires as to whether Mr Sarwar was required for cross-examination. In terms of the point made by my Lord, Lord Justice Arnold, on page 248 of the bundle, in response to the learned judge inquiry, I indicate, note the sixth defendant's application, which appears at page 89 in the bundle, and whilst we adopt the position taken by the third defendant, there is an issue concerning the medical report of Mr Zaitoon. And it's on that basis that Mr Sarwar hadn't, or his witness statement was silent as regards the points made.
Exactly. So your application was explicitly to cross-examine the witness upon a subject upon which he was silent.
My Lord, yes.
And the jurisdiction to make that order comes from where? And from where do you say that that's a proper exercise of the judge's discretion to make such an order?
Well, my Lord, I adopt the observation of the submission made by my friend Mr Rory in terms of the solicitor being an officer of the court. But what I would pray in aid is part 32.7 in that regard, which is the rule adopted by Mr Justice Saini in the High Court.
Right, so you say there's jurisdiction because the witness has given a witness statement on topic A, you want to cross-examine him on topic B, you say that 32.7 doesn't limit you. So that's where you stand on jurisdiction.
But
what about in terms of whether it being a proper order to make?
Well,
so when he is, as you point out, he's deliberately and explicitly limited his evidence to the third defendant's application, he has not addressed your client's application, not volunteered anything, and so therefore what you're trying to do is to obtain his evidence for the first time through cross-examination.
Well, my Lord, the point I would make is that Judge Godsmark didn't fall into error in terms of jurisdiction. In particular circumstances where claimant's counsel at that point raised no objection, and this was the point made by Mr Justice Saini in the High Court. Your Lordships will note on page 248, the judge indicates that the direction must be, well, before that point, we're going to require some live evidence in any event. He then indicates that parties can attend to give evidence, and claimant's counsel agrees with the learned judge's proposal. And the final sentence on that page and over the page, he indicates that it seemed to him that Mr Hunter, or possibly Mr Sarwar, would have been required to give oral evidence in any event.
So, can you help me on this? Leaving aside the exception identified in the Stokoe case of cross-examination of a debtor in bankruptcy, can you think of any other context within our system of justice in which a witness is called to give evidence and is cross-examined without giving any evidence in chief?
My Lord, no, and can I refer your Lordship to the Stokoe case, if I may?
So you would accept that we do not have cross-examination without evidence in chief?
My Lord, yes, but in this case, the claimant solicitors had been afforded the opportunity to file a witness statement. They had filed a witness statement. And the point is made in Stokoe by Lord Justice Bean on page 12 of the judgment, paragraph 31, that part 32.7 is of general application. And this was an appeal against the refusal to allow cross-examination on an affidavit relied on for the purpose of the Norwich Farmer Cal order. And Lord Justice Bean in paragraph 31 didn't accept the submission, that effectively an affidavit automatically opened the door to cross-examination.
So can I ask you this question? Now that it's been accepted by both respondents to this appeal that they do not allege that the signature on the reply to the Part 18 request was forged, it's entirely possible that Mr Sarwar's witness statement will be withdrawn. let's assume it is withdrawn. Do you say you can still cross-examine him upon the question of hearing protection?
That there is still a a power within Part 32.7.2 for the court to make or give a direction for permission.
Sorry, I'm baffled. 32.72. That's about using evidence where the witness doesn't attend.
Indeed. My Lord,
So how does that enable you to cross-examine a witness whose witness statement has been withdrawn?
Lord, I think we would be in difficulty in those circumstances, but of course Mr Sarwar hasn't withdrawn his application. And the court will note the subsequent order made by his Honour Judge Godsmark following the further hearing, where the appellants were given permission to file a further statement by the 19th of June.
But they didn't.
Indeed. My Lord, I would similarly wish to pray in aid in the authorities bundle, the case of, under the tab 3, Godfrey Morgan solicitors, a case to which the parties referred before Mr Justice Underhill, as he then was. In particular, my Lord, page 318 of the authority. Mr Justice Underhill indicates that it might have been on that basis open to one or more of the parties to submit to the judge. He could not hear oral evidence at all. Neither the claimant or Mr Clegg simply made a broad brush assessment on the basis of the statements. I'm not in fact sure that it would have been right for the judge to accede to such a submission in the circumstances. But the real point is it was not made. In my submission, it wasn't made in this case either. There are no submissions made to Judge Godsmark that he ought not to exercise his discretion or exercise jurisdiction to order cross-examination.
But it was accepted before Mr Justice Saini that didn't prevent the solicitors appealing. Are you withdrawing that concession?
My Lord, forgive me. The point made in Mr Justice Saini's judgment.
Yeah, it was accepted before the High Court that the solicitors were not debarred from appealing by Mr Trevelyan's failure to object at the hearing before Judge Godsmark.
Indeed, and
are you seeking to withdraw that concession?
my Lord, no. Mr Justice Saini then went on to exercise his discretion afresh by reference to the points made by Mr Justice Underhill in the Godfrey Morgan case. But in terms of the third respondent's position, my Lord, if one looks at the judgment of Mr Justice Saini, which appears in the core bundle of page 36, he makes the point in paragraph 33 of the judgment that, by way of a preliminary observation, this appeal, to say the least, is odd because the judge counsel representing the firm, who also represents the firm, clearly submitted to the judge that Mr Sarwar would probably be required to give evidence at the hearing. And similarly, in terms of the absence of evidence by Mr Sarwar, page 41 in the bundle, paragraph 28 of the page, he notes that notably, however, Mr Sarwar did not deal in any way with the substantial other, which was the confused and contradictory position put forward on behalf of Mr Hunt in relation to the hearing protection, or lack thereof, provided by the sixth defendant. And paragraph 46 on page 43, my lords.
Sorry, paragraph.
Paragraph 46, my lord.
Yeah.
He makes a point, Mr. Justice Saini, towards the middle of that, that paragraph, in the middle of the third and fourth matter. He makes the point, it may well be that it is rare to require the attendance of a representative to be cross-examined, pausing there in my submission that's consistent with the Raj House decision. And on any application of this type, but in my judgment, it's difficult to see how these issues could be resolved in a fair and proportionate way without oral evidence from Mr Sarwar. Your Lordships have been, Millennium Friends have addressed the court in respect of the jurisdiction and the authorities. Would it assist the court if I'm mindful of the time, would it assist the court if I took the court through very briefly?
The authorities?
The authorities.
Not unless there's any particular point you want to bring out.
My lord, no. I think it's being covered by my learned friends, and that's why I preface my
Yes.
comments that I don't wish to burden the court unnecessarily with submissions,
No.
which, given the relative lateness of the hour, may not prove. May I briefly turn my back?
Just before you do, can I come back to something I canvassed with Mr. Aurora, but relating it to your case? So suppose Mr. Sarwar goes into the witness box, not previously having dealt with the question of the provision of hearing protection, and you then seek to cross-examine him about that. He's explained in his witness statement that he had overall supervision, but other fee earners handled the case. And of course, he hasn't exhibited any attendance notes or anything of that kind. So you start cross-examining him, and he refers to the involvement of other fee earners, he refers to matters in attendance notes. How do you handle that?
My lord, I think this position, or the position in terms of the second limb to the sixth third respondent's application would be somewhat less involved than that in relation to the signing of the Part 18s. And what I would pray and aid is, clearly I've highlighted to the courts the potential discrepancies in the evidence. And whilst I appreciate, my lord, that the letter from Mr Hunt on page 79 in the supplemental bundle is after the event somewhat, but leading on from your lordship's questions. He indicates in the third paragraph, Walker Prestons have always been privy to all documents and information related to my previous employment, and have never given me reason to believe there are any discrepancies within it. Well, clearly there are obvious discrepancies.
Excuse me, what's that got to do with the question of whether Mr Zaitoon was wrongly instructed about the provision of hearing protection?
Well, there is obviously a discrepancy, my lord, because Mr Zaitoon says at first that hearing protection was provided. Second report, it wasn't provided, and the response...
This paragraph is all about the question of whether he's a director of Annolight.
My lord, whilst I appreciate that, it clearly indicates that in the course of proceedings that the appellant didn't give Mr Hunt any cause or reason to believe there were any discrepancies in the evidence.
So suppose Mr. Sarwar says X, Y, Z. Do you then call for the documents?
I would have thought that the purview or the scope would be somewhat more limited. The correspondence as between Mr. Zaitoon and the solicitor would clearly be of relevance, but I imagine that would be the sum total of the documentation.
But there's no order or even application for disclosure, even of that limited class of documentation.
My lord, no, but in terms of the discrepancy, I imagine in terms of cross-examination, that could be explored in cross-examination in very short order.
But once again, what these questions highlights is the bizarre prospect of a witness's evidence being obtained for the first time in cross-examination. Is it really your submission that that's an appropriate way to proceed?
My Lord, for the reason given earlier, whilst Judge Godsmark's order isn't mandatory in its import, there was an order to provide a witness statement in response that wasn't. When the issue of cross-examination was canvassed by Judge Godsmark, no opposition was raised at that point. So I say he didn't exercise his discretion erroneously in the circumstances.
Now, a little while ago, I prevented you from taking instructions, so by all means,
If I may briefly,
yes,
turn
please.
my back, my Lord. My Lords, unless I can assist the court any further, those are my submissions.
Thank you very much, Mr. Denton. Mr. Marvin.
My Lords, just two extremely brief points in reply to anything your Lordships want to ask me, both of which are what I put part of the context rather than at the core of it. I firstly, as regard the sixth defendant, the third respondent, I just want to make the observation that the allegation that my client improperly, if I characterise it this way, procured a change in the expert's evidence is not, I would suggest, apparent from the statement. I mean, if we were having the wasted costs application today, I'd be entitled to complain that that allegation hadn't been fairly put. The second point, as against my learned friend submissions for the first respondent, the third defendant, I do just want to say something about the revelation that apparently there is a letter from late August this year waiving privilege. It comes as a surprise to me. Forensically, of course, it's irrelevant to either Judge Godsmark's position in April last year or Judge Saini's position in December last year. And I just want to flag up, so it's not directly relevant, but obviously your Lordships have quite rightly travelled more broadly than the immediate issues in this appeal, that I thought I heard my learned friend say that this was on DACB note paper. Just in case your Lordships haven't made the connection, DACB are the solicitors who instruct my learned friend. So what would seem to happen, and it may well be that I'm not saying they didn't cause the claimant to get independent advice, but it seems that somehow or another, and I use this word neutrally, they have procured the claimant's waiver of privilege. And I just mentioned that does seem that measure of liaison, possibly cooperation between the claimant and the defendant does seem surprising in circumstances where the defendant is making the very serious allegation of fundamental dishonesty against the claimant. So I hesitate, I just raise this, I'm not, obviously it's not appropriate for me to ask my learned friend a question directly, but I just respectfully suggest to the court that the court might just want to check that we're not all proceeding on a false assumption, and that the application against the claimant hasn't been settled or withdrawn or anything like that, because that would be directly relevant to the issues that the court's been exploring about how the evidence might turn out. It just, I can't put it any higher than just to say it seems rather surprising that there's that liaison between the claimant and the defendant if the defendants are still accusing the claimant of being fundamentally dishonest. It's a matter for the court whether the court wants to inquire into that, but I just raise that as a rather surprising position. Unless there's anything else the court wants to hear from me on, those are my submissions in reply.
Thank you very much. Sorry.
I just had one question for you, Mr. Marvin. Of course, you're right that the waiver of privilege is irrelevant to the issues on appeal, but it strikes me that it might have some bearing on what the right order might be, depending on which way we decide the case.
Yes.
Because if the position now is that there is scope, other things being equal, for asking Mr. Sarwar some questions because there's no privilege objection, that could, under some circumstances, affect the way that we formulated an order.
It might do. I mean, my lord, if we're going, obviously, I haven't seen this document. My instructed solicitors haven't seen this document. I mean, we would want to have an opportunity to consider whether we accepted it was what it appears to be, an unqualified across-the-board waiver. I can see it might make a difference, but if the position is that the judges below were wrong to make the order, then of course it is still, particularly now it's confirmed that allegation of forging the signatures has been made against my client. It would has been put to my learned friend, and I think as friends broadly accepted. It would be open to us to withdraw the evidence. I can see it might make a difference, and I'm in some difficulty on the hoof thinking what that difference might be or how we might want to, respond.
I think all I needed was the answer that you've just given, which is it could make a difference. There's quite a range of possible outcomes, and that we ought to bear that in mind.
Well, more generally, it perhaps is worth articulating, which I'm sure is obvious to everybody in court, but let's just make it clear. If we set aside the existing order understood to be an order for cross-examination of Mr Sarwar on his witness statement, and indeed beyond his witness statement, that in itself, I'm sure you would accept, would not preclude a further application by the respondents for an order for cross-examination, in particular if it turns out that there has been a waiver of privilege, and if it turns out that you're not withdrawing Mr Sarwar's witness statement.
I would accept it doesn't preclude that. I might want to. My hands may be tied up by your lordship's judgment of this, but I might want to say it would still be wrong in principle, even if privilege had been waived given the summary nature of the procedure. But I would certainly accept that it wouldn't preclude a further application.
Yeah.
Thank you very much, Mr. Marvin. Mr. Aurora, let me just come back to you. Mr. Marvin has raised the question of whether there is any kind of agreement between your client and Mr. Hunt in relation to either the allegation of fundamental dishonesty or the wasted costs applications. Is that something on which you would wish to make any comment?
If I may turn my back,
Yes,
over. I
please.
think I know what the answer is, my lord, but no, there is no agreement or collusion, as my learned friend put it. No, and I would simply repeat that it goes. If one thinks back to my point about an excluded middle in terms of fundamental dishonesty or wasted cost, I say it's not surprising in those circumstances. But no, there is no agreement in relation to the fundamental dishonesty application.
Yeah. Well, in that case, thank you all very much. You won't be surprised to know that we will reserve our judgments. In the normal way, you'll be provided with drafts before they're handed down. As you'll know, that is to give you the opportunity to point out typographical and similar errors rather than to re-argue the case. I think hand down in accordance with current practice will be remote, but even were it not to be remote, then there's absolutely no need for anybody to attend the hand down. In advance of the hand down, we would be grateful if you would seek to agree a form of order giving effect to what we've by then said. And if there are any points of difference, could you please explain those in brief written submissions in advance of the hand down, and we would then expect to deal with those points in writing. But that concludes today's hearing. Thank you very much.
All right.